So a very warm welcome to everyone who is joining us this afternoon. But I shall be very glad of your attention whilst we consider from an English perspective some of the pension issues that await people encountering divorce with an international dimension. I see from the delegate list that we have a wide range of people this afternoon from different professional backgrounds and different countries. Now, some of what I say will be well known to some of you participating, but I hope there'll be something fresh and of interest to everyone involved. What we're going to be looking at is the main types of pension available in England, the law in 3 different jurisdictions other than England, just to illustrate how different the treatment of pensions is on divorce in different countries. We'll also look at the fairly esoteric topic of whether an English pension can be shared following a divorce in another country, and the flip side of that, whether the English court can share a pension based in another jurisdiction as part of an English divorce. And I'm just going to round the session off with a very brief look at the resources that are available to professionals and their clients to help with some of the international issues concerning pensions on divorce. So if we could move the slide on one, please. We're going to look at the main types of pensions that are available in England. I'm referring very specifically to England as shorthand for the legal jurisdiction of England and Wales, and that will be the case throughout this session. I have to be so specific because, as we shall see in a few moments, the law relating to pensions on divorce, even in Scotland, is very different to the English law. So I'm not referring to British pensions or UK pensions, I'm referring to English pensions. The word pension means very different things in different jurisdictions. And in England, a very wide variety of structures can constitute a pension for the purpose of a pension sharing order. There is a state pension that's commonly available in England. The basic state pension is not shareable. The additional state pension can be shareable. In addition to the state pension, there's a whole range of different private pensions that can arise as a consequence of employment or as a consequence of an individual making an investment in perhaps a self-invested personal pension, commonly known as a SIP. Running through all of those non-state pensions, there's one crucial distinction that anybody dealing with a pension on divorce in England and internationally really needs to grasp. And that's the difference between a defined benefit pension and a defined contribution pension. What's a defined benefit pension? Well, it's a pension that pays a defined amount to the pension holder. It's generally a pension that's derived from employment, perhaps a public sector form of employment, such as the police or the NHS, or it can be from a private employer, from a large listed PLC, for example. Although in the private sector, defined benefit pensions are much less commonly occurring than they were a generation ago, largely because they've become so very expensive for the private sector to provide. A defined contribution pension, on the other hand, is a pot of money to which the pension holder contributes and is then entitled either to buy an annuity or to draw money from the personal pension as they wish. And a really interesting development for divorce practitioners came just over 8 years ago now, on the 6th of April 2015, Pension Freedom Day, since when it's been possible to take all the money from a defined contribution pension in one go, albeit with potentially adverse tax consequences. So wherever you are in the world, if you're dealing with an English defined contribution pension scheme on divorce, it's important to keep a weather eye on that that scheme and come to a decision as to whether any sort of undertaking, or in an extreme situation, any form of injunctive relief is going to be required to make sure that that pension is available for the purpose that you would hope it will be available for your client. Another recent development in terms of English pensions has been relating to the lifetime allowance. Now, until the budget on the 15th of March 2023, the law was that an English pension could only have just over £1,073,000 invested in it before a lifetime allowance charge, a punitive tax, applied to that pension. Well, on the 15th of March, the lifetime allowance was abolished with effect from the 5th of April 2023. But it's important to recognise that the law may change in the future to reverse the now far more favourable tax treatment of the more substantial pension schemes that we have in England. Most pensions, as I say, not the basic state pension, but most other types of English pension are susceptible to being shared on divorce in England. There are a couple of examples of pensions where it is either impossible to share, or it is unlikely that the pension will be susceptible to sharing. I will give you a couple of those examples in the form of the bullet points that appear on the screen for you. The first one is the QROPS, the Qualifying Recognised Overseas Pension Scheme. That's an arrangement which meets conditions prescribed by the English Revenue, and it's intended for individuals who are or plan to be non-UK resident in retirement. Now, time doesn't really permit this afternoon a detailed consideration of a QROPS, but for today's purposes, it's important to note that an individual doesn't have to be non-resident to transfer a UK pension into a QROPS, as long as they plan to be non-UK resident in retirement. And it should be remembered that invariably a QROPS won't be amenable to a pension sharing order being made against it as part of an English divorce. Now, again, I mentioned the spectre of undertakings and injunctive relief to prevent a dealing with a pension that you wouldn't wish to see happen for your client. If you form a reasonable suspicion that the spouse on the other side of a divorce case is going to attempt to put an English pension into a QROPS in order to prevent it from being shared as a pension sharing order and under an English divorce, you may well wish to seek either an undertaking or to approach the court to seek an injunction to prevent that transaction from occurring. The other form of pension on which I'm going to touch this afternoon, in terms of what can be very difficult to share under an English divorce, is an employer financed retirement benefits scheme, an EFIRBs. They are widely recognised as an attractive alternative to a conventional pension provision for high earners, as well as acting as a top-up pension scheme. EFIRBs afford a means by which pension contributions and benefits can be maximised in a bona fide pension scheme, while giving flexibility for employees coupled with tax efficiency both for the employer and the employees. When an EFIRBs is established offshore, operating under a benign tax structure, it'll also be tax-free from the investment restrictions applicable to UK registered pension schemes. I would strongly recommend that if you have a case that involves an EFIRBs, you take specialist advice concerning it, because unlike the QROPS, which cannot be shared under an English pension sharing order, some EFIRBs may be susceptible to a pension sharing order, but that requires really careful consideration in the cases in which it arises, as do the tax consequences of such an order. So having looked at the types of English pension that there are and the possibilities for difficulty in an international context, I'm just going to bring us back to, if we can have the next slide, please, to look at a comparison of 3 jurisdictions outside of England, illustrating how different the treatment of pensions is on divorce in different countries. So within an English divorce, the court will take one of 3 main approaches to dealing with pensions. Probably the most effective, I was going to say best, I think it probably is in many instances the best way of dealing with a pension, is a pension sharing order being made against an English pension within an English divorce. And the effect of such an order is to take one spouse's pension, slice part of that pension off, and to create 2 pensions. The person receiving the pension credit, as it's called, will have an entirely new pension in their name. And the court order, and note this carefully, please, can only be expressed as a percentage of the pension to be shared. That gives rise to some difficulties, which must be drawn to the client's attention, in the sense that very often a personal pension will be invested in the stock market, and between an agreement being reached, an order being made, and importantly, the pension sharing order being implemented, the value of the stocks comprised in the pension can move up and down. So the client almost certainly won't receive the amount of money that they thought they would by applying a percentage of the pension when first it was valued. An adventurous practitioner attempted to persuade the court that it would be appropriate to give a pension by reference to the percentage that would produce an agreed amount, but it was decided in a case some time ago that that was not an acceptable interpretation of the law, and all English pension shares have to be expressed as a percentage. Pension sharing has been available on all divorce petitions that were issued on or after the 1st of December 2000. Another little elephant trap for people to be aware of is if you're dealing with a variation of maintenance case that's leading to a pension share, do be careful that the original divorce petition was issued on or after the 1st of December 2000, because otherwise there won't be jurisdiction to make the pension sharing order. So pension sharing, a great thing, relatively straightforward. I think testament to that is that there have been very few negligence actions brought against solicitors in relation to pension sharing orders, whereas they have in relation to offsetting, with which we will deal in a few moments. Before we get to offsetting, what is another way of dealing with a pension on divorce in England? A pension attachment order. That's a very little used remedy that's been available since July, I believe, 1996 with certainty. It doesn't share the pension in the way that a pension sharing order does. What it does is earmark some of the benefits of one spouse's pension in favour of the other spouse. It has severe limitations in that if an income is earmarked from one person to the other from the first person's pension, that income dies with the pension holder, unfortunately. So unlike the pension share that becomes the other spouse's, the pension attached income is not personal to the other spouse. One potential upside of a pension attachment order is that a pension attachment order can be made against the death benefits of a pension. That can be very useful in very discrete circumstances where a pension sharing order is not being made, because a pension sharing order and a pension attachment order cannot be made against the same pension. The third primary way of treating a pension on divorce in England is to offset the value of the pension as against other assets, most commonly the family home. that practice is fraught with difficulties for practitioners in England because it is very difficult to establish what the value of what can be a fairly nebulous asset in the form of a pension is, as against a more concrete, literally, asset in the form of bricks and mortar. I alluded briefly to negligence actions following divorce cases, and unfortunately there is quite a high incidence of disappointed former spouses bringing claims against their solicitors following a divorce because they don't feel that they've received fair value for the value with which the other spouse has been left in their pensions. Helpfully, within the last 12 months, there's been a table published by a prominent actuary called the Galbraith tables, which do go some way to providing a table a little bit like the Duxbury tables, for those of you who are familiar with Duxbury, or the Ogden tables for personal injury claims, which provides something of a ready reckoner for offset values, but I would treat with caution, and actuarial advice is very much the name of the game when you are dealing with an offset. Whether it's a pension sharing order, a pension attachment order, or an offset, there's no formula to the division of pensions on divorce. The court has a very broad discretion as to how to treat the pension as well as other assets. And after a long marriage during which the pension has been built up, more often than not, there's agreement that the pension benefits will be shared equally in England between the couple. But difficulties can arise when one person says, well, we've been married for 30 years, but for the first 10 years of my career, we weren't married, and I built up a substantial amount of pension entitlement that has grown over the 40 years, and I don't think that that should be shared with my spouse. Those arguments are often referred to as apportionment arguments, and they are commonplace. So with all that in mind about English pensions, let's look at the other jurisdictions that I'm contemplating this afternoon, of Scotland, France, and the US. Well, Scotland is only a couple of hours north in driving terms from where I'm sitting today, and the law that applies to the division of pensions on divorce is really very different from the law that applies in England. You'll remember me saying a few moments ago that where there's a pension sharing order, the English court can only deal in a percentage. Well, in Scotland, it can be expressed as either a percentage or a fixed amount, and percentages are rare unless it's a 100% share, and usually the share is expressed as a fixed sum. Again, in England, you'll recall that I was saying that there are often discussions over apportionment and whether a person has acquired either prior to or indeed after separation, and whether those acquisitions should be shared or not. Well, in Scotland, the value of all assets and liabilities built up from the date of the marriage to the date of separation are divided between the couple, and the pension is no exception to that. For pensions built up before and during the marriage, an apportionment has to be made in Scotland. A further distinction between these two very close jurisdictions is that in England, a pension can only be shared by a pension sharing order, whereas in Scotland, a share can be achieved either by a pension sharing order or a qualifying agreement within a separation agreement. We've travelled north. If we travel south across the sea to France, the treatment of pensions, and my knowledge of it is even more limited, but the treatment of pensions is even more different from the way that the English courts approach the issue. In France, I understand it's best not to think in terms of pension quotes sharing. Retirement pensions are apparently taken into account on divorce, but they aren't shared between the two spouses. And the French court will rule on whether a financial compensation is owed for communal funds paid into a spouse's retirement fund, or if compensatory maintenance is owed by the spouse with higher retirement rights, and any such payment will be in cash. However, the court won't generally specify from which account some compensating payment should be made, or which funds should be used to pay such a monetary award. The court will simply award the amount, and it's up to the spouses then to enforce on whichever assets are available if payment isn't made. So 20 miles across the water, the position couldn't be more different. Again, looking across the Atlantic, in the US, pensions can be shared under what's called a qualified domestic relations order, a quadro. Lots of US pensions have been far more accessible for far longer than English pensions. You'll recall I referred to Pension Freedom Day of some years ago. Well, for a long time, it's been possible to take a lot of cash out of a lot of different types of US pensions. The way pensions are taken into account in America and treated on divorce does vary from state to state. So the watchword there, certainly from an English perspective, is if you have an American pension at play, you do need specific advice and you need specific state advice to make sure that the best thing happens for your client. All of this really is very important in a world of international divorce clients, where a crucial issue has got to be decided right at the start as to where a divorce is going to take place. It might suit your client for there to be the full jurisdiction of the English court to make a pension sharing order against their pension, or to have one made against their spouse's pension. Equally, that might be the most substantial asset in the case. Your client might be very keen to defend that asset, and it might well be that in a different jurisdiction which the client can found, the pension can't be touched. There are real nuances around it as well, and real potential traps for people permitting a divorce, for example, to take place in England, because in England, very often it's to the detriment of the non-pension holding spouse for a final order of divorce or a decree absolute to be made before the issue of the pension sharing order is resolved. Once a decree absolute or a final order is made, the spouse may no longer have widow's rights, and they may not have an implemented pension sharing order. And if the pension holding spouse dies in that window, the pension credit will lapse, and the other spouse is going to be in a difficulty in terms of what would otherwise have been shared with them. So it is best practice in England, where you are for a spouse who may well be receiving a pension sharing order, to make sure that there is an undertaking before divorce proceedings are issued that no final order will be made until the pension sharing order has taken effect. Can an English pension be shared following a divorce in another country? If we could have the next slide, please. We've looked at the unique jurisdiction of England, the unique way in which England deals with pensions on divorce, and at 3 comparator jurisdictions. Can an English pension be shared following a divorce in another country? Well, since the 1st of January 2021, the English court only has jurisdiction to make a pension sharing order under the Matrimonial and Family Proceedings Act 1984, the MFPA, against an English pension following an overseas divorce, if one of the spouses is either domiciled in England on the date of the application, or one of them was so domiciled on the date of the overseas divorce took effect. Alternatively, one or both spouses would have to have been habitually resident in England throughout the period of a year, ending with the date of the application under the MFPA, or the date when the overseas divorce took effect. This is a much narrower jurisdictional test than was the position before Brexit, when reliance could be placed on Article 7 of the EU Maintenance Regulation to found jurisdiction. We're going to look briefly at domicile, habitual residence, and Article 7, just to give this a little bit of life and a bit of colour, because domicile and habitual residence have a very specific meaning in this particular context. Dealing with domicile, first of all, generally a person is domiciled in a country if they consider their permanent home is there. There are three types of domicile in this context: domicile of origin, domicile of choice, and domicile of dependency, which isn't relevant here because it only applies to children who are too young to require a domicile of choice. So a domicile of origin is a person's domicile at birth. If a person's parents were married when they were born, it's their father's domicile. And if a person's parents were unmarried, or if their married father died before they were born, it's their mother's domicile of origin. You can acquire a domicile of choice at any age of 16 or over, and it requires residence in a country other than the domicile of origin and an intention to remain in the country permanently or indefinitely. This can lead to all sorts of considerations if somebody is wanting to found domicile. It's a difficult issue and one that requires very careful and fact-specific consideration for each client. But if somebody is retaining their domicile of origin, the key question really, even if they live overseas, is whether they intend to live in that overseas jurisdiction permanently or indefinitely. Habitual residence can be described as the place where the person has established on a fixed basis their permanent or habitual residence and centre of interests, with all the relevant facts being taken into account for the purpose of determining such residence. You can only have one habitual residence at a time, and it's a slightly less sticky concept, if you like, than domicile. It can be established by the most rogue of facts. I've been involved in a case where somebody's acquisition of a Camden bus pass was sufficient to sway the court in the context of that person having a home and being present in the home for about 90 days a year, that of all the places in the world, England was actually their habitual residence. I mentioned Article 7 of the European Maintenance Regulation, which applied prior to January 2021. That was a real saviour for people wanting to have a pension sharing order made against an English pension following an overseas divorce, because it provided jurisdiction for the courts of a member state on an exceptional basis so that it may hear the case if proceedings couldn't reasonably be brought or conducted, or would be impossible in a third state with which the dispute was closely connected. So if you can imagine, for example, an English couple who have been living in Germany, if their domicile is German and their habitual residence is German and they're getting divorced in Germany, the German court can't make a pension sharing order against, say, the husband's English pension. Pre-January 21, what the parties could have done is use the maintenance regulation to found jurisdiction under the MFPA for a pension sharing order to be made under the MFPA against the English pension following the German divorce. Now they can't found habitual residence if they are living in Germany generally. They may be able to found domicile if they can persuade the court that that's the right way to go and that it is in fact one of their intentions to return to England following the divorce. So what's the profession doing about this? Because there are a lot of couples who are in difficulty over this issue. Various bodies have lobbied for a change in the law to establish jurisdiction on the basis that a pension is cited in England. Under the MFPA, there is jurisdiction to deal with a matrimonial home, and there is a hope that we might be able to extend the MFPA Part 3 to include a pension that is cited in England. However, to date, there hasn't really been parliamentary appetite to remedy the position. There is a potentially adventurous route to seeking an English pension sharing order using CPR Part 74 that permits the registration of a foreign judgment in England and Wales, but we're into really uncharted territory there. As I say, that would be something of a test case. Practical options for a couple who can't found jurisdiction under the MFPA and don't wish to take the untested route that I've just referred to could be to explore whether the English pension could be transferred to the jurisdiction in which the divorce is taking place, Germany in the example that I gave, to see whether it can be put into a vehicle overseas which would be susceptible to an order of the court in which the couple is living. Obviously, you could look at whether other assets could be shared rather than the pension, although that isn't always possible on the makeup of a couple's asset base, or whether there's the ability to draw cash from the English pension following the pension freedoms that we've discussed this afternoon, although tax is likely to be a material consideration if a substantial element of the pension is removed. Or you could consider a deferred implementation of an English pension sharing order once the pension is in payment, with a maintenance payment in the meantime. If we could have the next slide, please. We're going to look at that particular conundrum from the other end of the telescope, and whether the English court can share a pension based in another jurisdiction as part of English divorce proceedings. It became settled law that this is impossible with the decision of Mr. Justice Mostyn in Goyle and Goyle in 2016. An English court cannot make a pension sharing order against an overseas pension. Many people may wish to work around that to find a solution with their spouse. And again, I suppose a reverse of what we were talking about a few moments ago, it might be possible to transfer an overseas pension back into the English jurisdiction to make it susceptible to an English pension sharing order. A lot of complexity, a lot of things for us all to take on board. What help is out there? Next slide, please. The two main resources are the Pension Advisory Group report that was published in July 2019, with a second edition that's to be published later this year. That's a mine of information about English pensions. It has a section on international pensions and is a really good starting point to the professional. It's available online for downloading. The other great port of call is the International Academy of Family Law, the IAFL. Fellows of the IAFL have access to a global updater of what is possible in terms of the treatment of pensions across, I think it's about 100 jurisdictions in the world, to show how pensions are treated on divorce. If you're not a fellow of the IFL yourself, there's a list of fellows on the website, and I'm sure any one of us would be more than happy to answer any questions that you may have. That is really all I was wishing to say this afternoon. I hope you found the brief introduction to international aspects of pensions on divorce helpful, that it's given you some pointers for the cases that you're dealing with. I see that there's one question in the chat asking me to what extent is the concept of matrimonial property relevant, and how the court deals with pension assets on divorce. Well, I think matrimonial property, I think the questioner is asking me what the distinction is for matrimonial and non-matrimonial pensions, and that was really covered in the earlier part of my talk when I referred to apportionment. And if there is a non-matrimonial element to the pension, I think it's going to be a rare case in which that is going to be relevant. And I say it's going to be a rare case because ultimately at English law, it's trite, but it's true, needs trumps all. And an investigation of what income is going to be produced by the pensions in the vast majority of cases is going to show that the full income of both persons' pensions is going to be required to meet each person's income needs in retirement. So I think that was the focus of the question, unless it was to do with community of property, which is not a concept that exists at English law. Thank you for your attention.